Good evening. My name is Isabelle Teare with the WTJX NewsFeed, and this is Trial Watch. Now, today was day 6 of the case, the United States of America versus Ray Martinez and Jenifer O'Neill, and the case is now officially in the hands of the jury. But I was in court all day today, so let's dive into everything that happened before it was handed over to the jury. So this morning, we started off by hearing from the attorneys from Ray Martinez. As anyone who was watching yesterday or has been following will know, yesterday Ray Martinez said that he still wanted more time to decide whether or not he was going to testify as part of his own defense. But this morning, his attorney said that Mr. Martinez will not be exercising his right to testify. So after that, the judge and the attorneys went back into the judge's chambers where they went over the jury instructions. We didn't get to hear this. This was done in private. It took around 2 hours where they were just going over these instructions that will be read to the jury later and that I'll talk about later on. Now, after that break, and after this had been done, we heard these oral arguments on the Rule 29 motions that I discussed yesterday. Now, this is all done outside of the presence of the jury. The jury was not here yet. They were asked to arrive today at 1 p.m. So all of this was happening before that. And these Rule 29 motions are motions that the defense makes, basically just saying that the United States hasn't, met the burden of proof for their case, that the evidence isn't sufficient. I kind of characterized it yesterday as a little bit of a Hail Mary that the defense, I believe, will typically do. So we started off by hearing oral arguments from Ray Martinez's attorneys on this. This was Miguel Oppenheimer, and his Rule 29 arguments were very kind of procedural. He ran through all of the counts that Ray Martinez is charged with. And for each one, basically just said the evidence was insufficient to sustain a conviction and that the United States had not met their burden of proof. Now, we then moved on to the oral arguments by Dale Lionel Smith, this Rule 29 motion. And his arguments were more in depth. And he spoke a lot about things that he'd said in his opening statement. So I'm not going to get into too much detail because it'll be very repetitive. We've heard this, and then we're also going to hear it again in his closing arguments. But the legal argument that Dale Lionel Smith was making was, first of all, what we've heard a lot about was that his client was not aware of the conspiracy to commit bribery. And this is where he dove into kind of his legal argument for the motion to dismiss. He said that committing bribery is a necessary component of the honest services wire fraud charge. And he said that if his client is found not guilty on the bribery charge, she cannot then be found guilty on the honest services wire fraud charge. Basically just saying that because honest services wire fraud he was saying that honest services wire fraud can't exist without bribery, and that if she is found not guilty on the bribery and then therefore found not guilty on honest services wire fraud, she then can't be found guilty of money laundering. And those are the 3 things that Jenifer O'Neill is charged with. So what he was basically saying is that bribery is that first domino, and if that domino falls, all the other dominoes fall too. A couple other points he made during this, his arguments to the judge. He said that the objective and reasonable evidence that had been presented was that there was a rogue individual working for the government to try and entrap his client. He said the evidence wasn't sufficient. And then he also said something that we haven't heard yet in court. He said that for all Jenifer O'Neill knew, her friend Ray Martinez was just happy to give her the $17,000 for this lease because he was a friend. And this is the part that we haven't heard yet. He said maybe that was coming from David Whitaker simply because Ray Martinez didn't want his wife to know that he was giving money to Jenifer O'Neill. He said that Jenifer O'Neill, there was no way for her to know that this was bribery. So after these arguments, we then heard from Alex Dempsey, the prosecutor, and he kind of just said that he responded by saying the United States has presented an abundance of evidence in this case. He also went on to say that Dale Lionel Smith was misrepresenting things to the court in those arguments. He actually said it was inappropriate for Dale Lionel Smith to reference Ray Martinez's wife because there was no evidence to that effect, meaning reference Ray Martinez's wife in the way he had said that the money was coming from David Whitaker because Ray Martinez didn't want his wife to find out. He also said that there was no evidence of entrapment in this case and no jury instruction on entrapment. So that wasn't something that could be argued. So then the judge, after hearing all of this, started asking some questions to make his ruling. And he got into, really questioning Alex Dempsey on certain arguments. He said to Alex Dempsey that one of the charges against Jenifer O'Neill has to do with her expediting one of these payments. And he asked Alex Dempsey, so what is the evidence that Jenifer O'Neill was going to benefit from that? Because in order for it to be bribery, there has to be a benefit. And Alex Dempsey said two things. He said, first, she can be found guilty even if it wasn't her directly benefiting, as long as someone was benefiting. But then he also said that there was evidence that she knew she was going to benefit from this $70,000 invoice inflation. The judge then said, okay, well, Ray Martinez said he told her it was a gift. And he's referring to the conversation we overheard, that recorded conversation where Ray Martinez was talking to David Whitaker about going to Jenifer O'Neill's office and telling her he was going to give her a gift, and how he says that she called him big bro, that whole conversation. So the judge says, how does Jenifer O'Neill know anything other than this was a gift? And Alex Dempsey said, well, in that brunch meeting that we heard the recording of between Jenifer O'Neill and David Whitaker, he said at that brunch meeting, they're discussing the money on the invoice and how it is going to benefit her. The judge then said, okay, now let's assume that David Whitaker is just this chatterbox. And he goes out and he tells all of his friends that he's getting this $70,000 on this invoice. He said, okay, so the people who hear that, are those people subject to honest services wire fraud? And Alex Dempsey said, only if they get involved in that fraud. And so then the judge then asked, okay, so he asked again, what's the evidence that she had knowledge? And Alex Dempsey said, at the brunch, David Whitaker informs her of that $70,000 invoice. The judge says, okay, well, that's not a crime. And Alex Dempsey said, yes, correct. But she is now aware. And then there were the texts that between her and David Whitaker, and that message further informed her of the corrupt action. And then he said Jenifer O'Neill took an official act to further the conspiracy. So then the judge asked, okay, so you're saying the official act is the message to Jamie Gaston. Jamie Gaston is that employee at OMB who we heard testimony from yesterday. And Alex Dempsey said, yes, correct. So then the judge said, okay, you've answered my questions. And we moved forward, and the judge then ruled on these Rule 29 motions. He said that he said the United States had provided sufficient evidence, and he denied Ray Martinez's motion. Then he actually went on to speak about the motion presented by Dale Lionel Smith. And he said, as to this motion, it was well presented, but he said in terms of the question of does the jury have to find bribery to find honest services wire fraud, he said that in the governing cases in this circuit, the court makes it clear that it doesn't need to be a bribe. It can just be conduct that denies citizens their right to honest services. It doesn't have to be exactly bribery. And so therefore, he denied Jenifer O'Neill's motion, Rule 29 motion. He then also got into discussing the things Dale Lionel Smith had talked about entrapment. And he said that there was no entrapment defense allowed here. There was no evidence of entrapment presented. And basically that Dale Lionel Smith wasn't allowed to kind of raise this in front of the jury. Okay, at this point, there was a recess. There was a lunch break. And when we came back, we first heard directly from Ray Martinez that he did waive his right to testify. After lunch, Ray Martinez was now in the courtroom again, as was Jenifer O'Neill, in addition to their counsel. Then the jury entered and the judge looked at them and said, okay, so the evidence is in, the book is closed, but we still have closing arguments. And he explained the way that it works is that the United States does their closing argument, then Ray Martinez would do his closing argument, and then Jenifer O'Neill would present her closing argument. And then after that, the United States does have a chance to give a rebuttal after hearing those. So the United States' closing argument was done by Charisse Amaro. And she got up and she had a mic hooked up to her so she could walk around the courtroom. And she was speaking directly to the jury while she was holding kind of a folder that she would occasionally look at and reference. She started off by saying that in her opening, she told the jury that this case was about calculated corruption by two of the most powerful officials in the territory. And she said that over the last week, they had heard the story of how bold this scheme was and how desperately they tried to cover it up. She said that these defendants didn't stumble into this scheme. She said that they walked in, they chose, they knew what they were doing. The jurors, while she was saying this, were looking, right at her. They did seem to be very engaged in what she was saying. Then Charisse Amaro said that Jenifer O'Neill knew what was going on. She said she approved that invoice anyway because she wanted her cut, that $17,000 for the Java Grand deposit. She said this was all calculated, deliberate, and corrupt. And then she looked at the jury and said, now it is your responsibility to hold them accountable. At this point, Charisse Amaro also put up a PowerPoint presentations, and she was using that PowerPoint to kind of go over all of the elements to the different counts and the ways that the United States, had met all of these counts with sufficient evidence. While she was doing her closing arguments, I also did notice that one of the jurors had their eyes closed, but it wasn't in a way like they were sleeping. It was almost like they wanted to be listening more intently. She then went on to discuss how, both of these defendants accepted things of value from David Whitaker. I'm not going to go into all of it in detail, but these are things that we've already discussed. Ray Martinez, she said, getting restaurant equipment. There were construction costs for his restaurant, the rent for his house, the tuition for his kids, the grill at his house, the flights to Boston, the hotel suites, the sports games, the expensive dinner. She also then pulled up photos that we've already seen of Ray Martinez in that Encore hotel suite. Also the photo of Ray Martinez using that fancy grill at his house. She then talked about Jenifer O'Neill, said Jenifer O'Neill accepted over $17,000 for her restaurant lease, and that she was aware of this. They all were. And we know that a lot because of this April meeting that was held at the Monethos office that David Whitaker recorded, where all three of them are discussing how they're going to spend the $70,000 from the inflated invoice. This is the conversation where we heard Jenifer O'Neill and Ray Martinez say, everything is traceable. We also then again saw the wire confirmation showing that David Whitaker did send to Yacht Haven Grand paying Jenifer O'Neill's lease deposit. Charisse Amaro then said that this was a quid pro quo relationship and, you do something for me, I do something for you. She said that there was no innocent explanation for what Jenifer O'Neill did. She said she then brought up those text messages that we've seen. They were displayed on the screen. The texts where David Whitaker asks Jenifer O'Neill about the status of this $216,000 invoice. He also in this text says, Ray will be upset if he doesn't get this $70,000 for his restaurant. He'll also be upset if he finds out we're going to the Encore and a game. And this is the one where we see Jenifer O'Neill respond, LOL, I'll have my staff check. And Charisse Amaro, in referencing this, said, the director of OMB's response to this was LOL. She thought it was funny. She didn't ask any questions about what he was saying because she knew exactly what was happening. Amaro then said that the same day Jenifer O'Neill went and texted Jamie Gaston. She made a point to say that this text was on a Saturday. She said Jenifer O'Neill knew that approving that invoice would unlock money that she would receive. She then said that that Jenifer O'Neill even discussed ways that she would hide and cover up getting that money. And then she referenced that recorded conversation at the Monethos office where we hear Ray Martinez, Jenifer O'Neill, and David Whitaker talking. And we hear Jenifer O'Neill say, I don't like traces of anything. Amaro then said, if Jenifer O'Neill had no knowledge, if she thought these were legitimate business transactions, why would she be worried about it being traceable? Amaro said that the people of the United States Virgin Islands deserve the honest services of their police commissioner and the director of the Office of Management and Budget. She said that the defendants acted willingly and deliberately. No one pulled wool over their eyes. She said their actions weren't accidental, they were intentional, and that she really was drilling on the point that nothing about Jenifer O'Neill's conduct was accidental. She also then began hitting through, some more procedural things that the jury will have to understand in order to meet certain elements of certain counts. So Charisse Amaro said that these transactions did constitute interstate wire fraud because First Bank has no servers in the United States Virgin Islands, and therefore all of the transactions had to cross state or territory lines. She said that the jury had heard in the defendant's own words, in the defendant's signatures, their approvals, their texts, and that this was proof beyond a reasonable doubt that they, had chosen to do this. An observation, I did see Jenifer O'Neill taking notes. She was writing something in a small notebook while Charisse Amaro was giving these closing arguments. Then Charisse Amaro did get into discussing how Ray Martinez is the only one charged with obstruction of justice. Jenifer O'Neill is not facing that charge. And Amaro said that when Ray Martinez realized that FBI agents were closing in, he immediately started trying to make evidence disappear. She then pulled up those conversations where Ray Martinez says, burn the phone to David Whitaker, says, destroy it, bro. She told the jury that this was the police commissioner telling this person to destroy evidence. Then she said that Ray Martinez also started making fake evidence. And she was talking about that promissory note that she said was created in June 2024, even though Ray Martinez had signed it and put the date of August. What date was that? August 15th. So she said that this document was created after Ray Martinez started panicking. She then said to the jury that the United States was asking them to find both of the defendants guilty on all of these charges. And this was the end of her opening argument. As an observation, the jury, as I said, seemed very attentive, but this is something that I've kind of been meaning to bring up all week. The courtroom that we're all sitting in is freezing cold. Everybody is very, very cold. People on the jury have blankets with them. They're wearing jackets. And today, I even saw one of the jurors had put on actual gloves. She was sitting there holding kind of a hot drink, wearing gloves in this courtroom. So after Sharice Amaro's closing arguments, we then heard closing arguments from Ray Martinez's attorney, Miguel Oppenheimer. Now, this is a big moment in this case because thus far, we really haven't heard the defense do kind of this direct presentation of their whole defense. We didn't hear them give an opening argument. So this is the first time that we're hearing them really spell out their case. And Miguel Oppenheimer started by looking at the jury and saying, you've heard the words corruption, you've heard the words bribery. He said, those are big words, those are accusations. But he then looked at the jury and said, you need to consider, though, what is missing. He said, is evidence missing because it doesn't exist? Or is there evidence missing because the United States didn't present it to us to consider? He then went into talking about the Monethos contract. And he said, the United States tells you that this Monethos contract between the Virgin Islands Police Department and Monethos, they say that this was the result of a bribe. But he said to the jury, you've heard testimony that the Department of Property and Procurement were the ones who said that this Monethos contract needed to happen. He said that not only did you hear it from the current commissioner, Lisa Alejandro, but that you heard testimony about this from a former PNP commissioner, Anthony Thomas. He then said that the contract took 6 months, that it didn't happen overnight. He said it had layers and layers to it, layers of vetting, many different eyes looking at it. And he linked that all back to Lisa Alejandro's testimony. He said that Ray Martinez didn't have anything to do with making this contract happen, that once again, it was PNP who made the decision and wanted the contract. He then went into talking about the relationship between David Whitaker and Ray Martinez. And he said they had 3 different kinds of relationships. He said the first kind was a professional relationship between a government agency and a government contractor, between VIPD and Monethos. He said the second kind of relationship they had, though, was a business relationship outside of all of this. He said that business relationship was the stakeout agreement of them trying to make this show. And then he said the third kind of relationship they had was a friendship. And he pointed to all of these conversations they've had, the way they greeted each other, hearing Ray Martinez say, "Yo, David," a lot when he answered the phone. He then started talking a lot about the stakeout agreement. He actually pulled it up on the screen for the jury to see. And he said that this agreement, set the ground rules of this legitimate business venture that these 2 adults were, getting into. He said the agreement says that David Whitaker was going to assist in funding and bringing media experience to this venture. And he said the physical space was going to be the restaurant, and that the restaurant was essential for this venture to happen. And that part of the agreement was David Whitaker was going to bring funding and equipment to the restaurant. After this, he said something kind of interesting to the jury. So side note, the attorneys for Ray Martinez are both from Puerto Rico. They have Spanish accents. And he said that there's a saying in Puerto Rico. And the saying is, a rooster does not sing any clearer than this. And he said that in relation to this stakeout agreement. He also said that the agreement was drafted by Joseph Bolero, who he said was David Whitaker's longtime lawyer. Again, talking about the legitimacy of this agreement. And then he went on to say that all of the payments for this restaurant equipment to Ray Martinez happened after this agreement was signed on April 1st of 2023. And then he said that these payments that the United States has been presenting, he said none of these payments were made in an envelope in the Rancho Latino parking lot late at night. They were traceable. They weren't hiding anything. Nothing about this was sketchy. He said stakeout hasn't happened yet because the restaurant just opened. So he said they hadn't gotten there yet. He said the payments weren't bribery, they were part of a legitimate business relationship between two adults. Now, I took a moment to kind of look up at the jury as he was giving these closing arguments. And I've got to be honest with you, aside from seeing that everyone is very cold, it's hard to get a read. I'm not seeing any facial expressions really. They look serious and attentive, but nothing really beyond that. Miguel Oppenheimer then brought up the invoices that we've heard so much about throughout this case. And he said the government pays invoices at a very slow rate. He said Anthony Thomas had told us in his testimony that he routinely had to call the Virgin Islands Police Department about getting Mon Ethos's invoices paid. He said that Mon Ethos was having to call and follow up all the time. So if it was bribery, if this was a bribery relationship, why weren't the invoices getting approved faster? He then moved on to discussing this personal relationship that he told us about between David Whitaker and Ray Martinez. And he really focused on the trips to Boston here. He said that David Whitaker and Ray Martinez went to Boston because Ray Martinez needed brain surgery. And that Ray Martinez called his friend who had used to live in Boston for advice and for help to find doctors. He said Ray Martinez wasn't going to Boston for fun. He went to Boston for brain surgery, and his friend came with him. He then brought up that photo of Ray Martinez standing in the suite of the Encore Hotel in Boston. And Miguel Oppenheimer said, you see a photo of a man in a nice living room? Well, I see a photo of a man who is alive, a man who just survived brain surgery. He then said, you've heard so much about that very expensive dinner at Rare. This is the steakhouse in Boston where the U.S. says that Ray Martinez and David Whitaker spent over $1,000 on this one dinner just between both of them. But Miguel Oppenheimer said, we haven't seen a receipt from that dinner, have we? We saw, that money was paid to the restaurant, but we never saw the receipt. How do we know it was only for two people? Maybe they just got a very nice bottle of wine because they were celebrating a successful brain surgery. He then said the prosecution cannot seem to understand that after brain surgery, you have to have follow-up doctor's appointments. These other trips to Boston weren't for fun. They were for legitimate doctor appointments. He said that this wasn't an ingrown toenail we were talking about. This was brain surgery. He then moved on to talking about that inflated invoice that we've really focused on a lot in this case. That is the one where $70,000, or the United States says $70,000 was added as a line item. And Miguel Oppenheimer said, we've heard so much about this, but we've never seen any of the invoices with these line items that the United States is talking about. He said that is missing evidence. These invoices are missing evidence. We haven't seen an invoice for $216,000. He then went on to discuss again how everything that was bought for Ray Martinez for the restaurant was bought after April 1st, after that stakeout agreement was signed. But he did bring up a transaction that the United States had presented, which was in November of 2022. That would have been before the stakeout agreement. And this was for over $3,000 to KLR services. But what Miguel Oppenheimer said was that, have you seen a single receipt in this case from KLR services? We don't know what that $3,000 transaction was for. And then he brought up a bank statement from David Whitaker showing that a few days after that November 2022 $3,000 to KLR, that David Whitaker spent over $1,000 at Gourmet Gallery. And so Miguel Oppenheimer was saying maybe David Whitaker bought himself a grill. And then maybe the next day he went and bought a lot of food for himself. How do we know that this was for Ray Martinez? Oppenheimer then said that briberies are supposed to be hush-hush, but all of these transactions were wires. They were traceable and they were out in the open. He then talked about that promissory note, and he said that promissory note wasn't obstruction of justice. This wasn't a false record. He said this was Ray Martinez getting an agreement in writing about an oral agreement he had with David Whitaker about money that was being loaned to him. And he said also on the promissory note, you'll notice that the repayment is meant to begin after Don Filito's cook shop opened. And he said Don Filito's cook shop just opened. He then started talking about the testimony of David Whitaker, and he said that he didn't have enough time to get into all of the issues and everything about David Whitaker. But he did say David Whitaker had a long criminal history. And then he kind of caught himself here. He said, well, not a long history. He has a previous conviction for fraud in 2008, and he then pled guilty to fraud in the Virgin Islands. A side note, this was just kind of an interesting moment because it did seem like he caught himself because we know that the judge restricted evidence and testimony about all of these prior criminal acts of David Whitaker to come in. Miguel Oppenheimer said that in September of 2023, when the FBI approached and contacted David Whitaker and he became a cooperating witness, that the FBI knew that David Whitaker was a convicted felon and that the next month they then allowed him to get a government contract, that was against the law. It wasn't allowed. He said that the FBI allowed this to happen because they wanted to take down a career law enforcement officer, someone that Ludwig Thomas testified yesterday and told us worked 12 hours a day, who was a hands-on police commissioner, who wanted to help his people, who was a local of the U.S. Virgin Islands. Then Miguel Oppenheimer went into wrapping up his closing arguments, and he told the jury, I've given you all of the reason the United States hasn't met their burden of proof. Please think about all the evidence that you're missing. He then brought up the missing invoices again. He said, I'm asking you to use your common sense. Look at the evidence or lack of it. If you have any reasonable doubt, you must return a verdict of not guilty. So that was the closing argument for Ray Martinez's, from Ray Martinez's attorneys. And we then heard the closing arguments for Jenifer O'Neill by Dale Lionel Smith. And Dale Lionel Smith started out in an interesting way. He was walking around the courtroom, looking at the jury, and he said to them, imagine that you're in your home and you get a call from your friend who says that they need a favor from you. And they ask you to come give them a ride, to get in your car and come get them. They say that they're making a withdrawal from a bank, a withdrawal of cash, and that it's a large withdrawal and they don't want anyone to take it. So they need you to come help them. So you get in your car and you drive down there, and then your friend comes running out of the bank with this bag, and they get in the car and they say, drive, drive, drive. They're coming for my cash. He says, and then 10 minutes later, all of a sudden you're surrounded by police and you're charged as an accomplice in a bank robbery. He said, yes, you maybe drove your friend, but you didn't know what they were doing. You didn't have any knowledge of that. He then said that he was glad that the United States understood that you can't just stumble into a conspiracy. And by saying this, he's referring back to Charisse Amaro's closing arguments, where she said these defendants didn't stumble, they walked straight into this knowingly. He said, what we've heard a lot from him, that to be involved in a conspiracy, someone must inform you, and you must join that conspiracy with the intent to further it and the intent to see it succeed. He said that there was a lack of evidence that his client joined in a criminal conspiracy with the intent to make it succeed. He then looked at the jury and started, talking about David Whitaker. And he said, ask yourself, why would the United States base a case that is built entirely on the testimony of a prolific liar? He said, you heard that the FBI testified that they did not trust David Whitaker. So why should you? He then went on to say that he admitted that the FBI is the premier law enforcement agency in the United States, but he said the FBI is asking you to find my client guilty based only on the testimony of David Whitaker, based only on his investigation, not that. He then went into talking about how the true conspiracy that is being discussed in this case began in August of 2022 with David Whitaker and Ray Martinez planting those listening devices. And he said that his client confronted David Whitaker about a lie that David Whitaker, pushed out through his media channel, USVI News, that said that Jenifer O'Neill was the one who had told them about these listening devices. He said his client confronted David Whitaker back then about this and said it wasn't true, that she was upset about this. So why would she then join into a conspiracy with him? He then said, fast forward, the FBI now sends David Whitaker to get a big fish. He said that the FBI, he said to the jury, they, referring to the FBI, were interested in the governor. He said that Jenifer O'Neill was a victim of the FBI's quest. He then went on to once again talk about David Whitaker, and he said that David Whitaker was a criminal and a sociopathic liar. And he said, this is who the FBI and the government, these prosecutors from Washington, D.C., that's who they are basing their case on. He said that increasing an invoice doesn't mean criminal activity is afoot. It could very well be for something like more cameras. He said that, Jenifer O'Neill getting this text that Ray Martinez would be mad if he doesn't get $70,000, she doesn't know what that means. He said that to commit a conspiracy, they have to say, we're going to rob a bank, bring a gun, a bag, and get in the car. You'll get this much money. He said that David Whitaker, all he was trying to do was get more people, in trouble, if you will, to help him get off. He said, David Whitaker was saying, send me after them. That's what David Whitaker was doing. He said, Miss O'Neill is collateral damage of David Whitaker's corruption. He then closed out his closing arguments by saying it might be good for the DC, meaning the Washington, D.C. prosecutors, to say everyone in the Virgin Islands is corrupt. But we won't do that on the word of a sociopathic liar. He said, we're better than that. And the last thing he said was, I'm really afraid for my client. These are very serious charges. I'm asking you, did the United States present enough evidence? Was it reliable evidence? And can that evidence, he said, and can that evidence convince you beyond a reasonable doubt? Now, this was the end of his closing arguments, and we moved on to a quick rebuttal by Alex Dempsey for the United States. And Alex Dempsey said, the government doesn't pick the criminals that become co-conspirators. These co-conspirators pick each other. He said, yes, David Whitaker is a convicted felon, and we told you that. But you're the judge of whether these defendants chose to join David Whitaker, chose to join that convicted felon. He then said that stakeout was fake, that the jury has heard evidence that it was all a sham to cover up payments. He said, yes, that October 2023 contract between Monethos and VIPD, yes, there were many steps and many eyes saw it. But he said the jury also heard testimony that if they had known that someone was getting, illegally bribed to make that contract, that they would not have signed it. Then he, rebutted the argument that these payments were out in the open, that they were traceable, and therefore they couldn't have been doing anything bad. He said, these documents, these wire transfers, these bank records aren't easily accessible documents. They were obtained by a grand jury subpoena. They're extremely difficult to get. And he closed out his rebuttal by saying that reasonable doubts are not based on guesses or based on conjecture. They aren't based on coming up with other reasons to maybe justify certain things. He said that the United States wasn't asking the jury to trust the word of a convicted felon. He said that the jury heard the defendants in their own words, in their own voices, their own messages. He said, you have the evidence. Okay, and now that was the end of these closing arguments. And then after this, the judge giving the jury their jury instructions. Now, this took an hour and a half for the judge to run through. These are the instructions that the judge and the attorneys spent 2 hours this morning going over and making sure both sides agreed on. So I'm just going to run through a quick important points. He told the jury that it was their job to decide the facts based on the evidence that they'd heard. He said that they didn't get to make decisions based on what they thought they should be. He said, if you want to change the law, if you disagree with the law, this wasn't the place to do it. He also said the verdict of the jury had to be unanimous. And then he talked to them about what was evidence and what wasn't evidence. He said evidence is testimony of witnesses and the exhibits you saw. He said things that were not evidence were the statements and opening statements and closing arguments by the lawyers. He said the questions the lawyers asked were not evidence. Any objections or his ruling on objections, those weren't evidence. He told the jury they had to use their common sense in weighing all the evidence. And then there were two important things because they talked about the credibility of witnesses. And the judge told the jury that they were the sole judge of the credibility of a witness. He said that they could believe all the testimony of a witness, some of the testimony of a witness, or none of the testimony of a witness. He said, you decide if you believe what they say. And you decide this by using your common sense, your judgment, and your experience. But then he did mention David Whitaker specifically in these jury instructions. He said to the jury, you should use caution in evaluating David Whitaker's testimony. He said David Whitaker is a cooperating witness. And as a cooperating witness, he may receive a reduced sentence in exchange for truthful cooperation and truthful testimony. But he also did say this wasn't the job of the attorneys or anyone else or even himself at this point to decide. This was only something that would be decided at the sentencing. He also said that the jury could not use the fact that neither Ray Martinez nor Jenifer O'Neill testified in their decision. And then after going through all of these jury instructions, we found out who our actual jurors were going to be. So you may remember from the first day when we talked about, the choosing of the jury, that we have 15 jurors who have been sitting there listening to this whole case. But not all of those 15 jurors are going to deliberate. Only 12 of them do. 3 of them are alternates. And they're alternates in case something happens to one of the other jurors. That juror can step in. And the alternates are not told that they're alternates for the very reason that the court wants them to be paying attention to the evidence and paying attention to the case as if they were the ones who were going to go back into the room and deliberate. So after these jury instructions, the 3 alternates were announced and taken away. All 3 of the alternates were women, and the only 2 white people on this jury were of those 3 women. So the remainder of the jury on this case is black. There are 8 women and there are 4 men on the jury. And after the alternates had been dismissed, these 12 jurors then were sent back into the deliberation room and told that they needed to choose a 4-person. They were also told that they could begin their deliberations this evening. However, at this point, it was after 5 p.m. So all that happened was the jury sent their first note out. And this is how the jury is going to communicate with the judge and with us throughout their deliberations. They choose a 4-person, and that 4-person will write any questions they have on a piece of paper. That piece of paper is then sent to the judge. The judge reads that in open court, and then the judge and the attorneys respond to that question that they have. So we did get that first one this evening, and the juror 4-person wrote that the jury wanted to just come back tomorrow at 8:30 a.m. to begin deliberations, and that they also requested a copy of what they called the law document, but the judge said he believes they're talking about the jury instructions, which they will get a paper copy of those jury instructions. Okay, so then everyone was dismissed for the evening, and the case is now, as I said at the very beginning, it is officially in the hands of the jury. Tomorrow morning, 8:30 a.m., they will officially begin their deliberations, and we will be waiting in the courtroom for any developments and waiting for that verdict. So I will see you again tomorrow, depending on what happens actually tomorrow, for an update. Once again, my name is Isabelle Teare with the WTJX Newsfeed, and this is Trial Watch. Thanks for tuning in.